No? There. We're live. How are you? Can you hear me?
Oops. I can't.
I can.
Now I can. Okay.
Cool. This is a handy little thing. So how are you?
I'm all right after my chaotic morning, thinking I was going to have to run all over town and do all kinds of things and change my whole schedule. And then we figured out that we had already dismissed the cases the court thought were set for trial, and the court just hadn't processed them. So,
Oh, nice. Okay. So I usually do just a little introduction.
Sure.
You know me, I'm Angel. I'm the CEO of Mastiff Home Buyers. I'm doing these weekly just as an effort to get information about out there to property owners, particularly those who may get themselves into distress situations, who may need resources in order to either keep their home or get their home sold or get deeds sorted out or those kinds of things, like we're going to talk about today. So I'm here with Audrey Young. You want to introduce yourself?
Sure. I'm an attorney. I've been working in real estate for about 15 years. For the last 10, 11 years, actually, I've been focusing on landlord-tenant work, but I also do foreclosures, quiet title actions, things like that. I also do estate planning, and there's a lot of intersection there between estate planning and real estate as well.
Yep, there sure is. So this is going to be really informal. I have some guiding questions, but of course, we want you to bring your expertise to the table and advice, anything that you can advise people about. And today we wanted to talk about the right way to record deeds in particular, as we know a lot of people, and I've run into a lot of people who do their own recording or they think they do. So some examples are they did the paperwork, but they never recorded it. And then someone dies. And, then that creates some challenges. So that's kind of what we were going to talk about today. But you shared a little bit about you. Do you want to share a little bit about your firm or anything about your?
Sure. I just joined as of November 1st, a new firm as a partner. So that firm is Basson, Young, and Bargenbrook. And we have offices in Lee Summit and also in Overland Park. And we're exclusively a real estate firm with the exception of my estate planning practice. So
Okay.
it's nice to be involved. It's nice to be working with a couple of attorneys who also do, pretty much exclusively real estate work. And there's a lot of knowledge there to draw on, which is nice.
Yes, it is. So how did you get started in this? What's your kind of background and passion?
I kind of fell into it. I graduated from law school in 2007, and we all know what was happening at the end of 2007, beginning of 2008. There weren't a whole lot of jobs out there. So I was just trying to do whatever kind of work I could to, pay those student loan bills. And I met an attorney who handled a lot of estate plan, probate type work, estate planning and probate. And he also did real estate. And I said, hey, can I, do you need a part-time associate? So I started working for him part-time and then more. And he did a lot of lease review work and a lot of he did a lot of cell phone tower lease reviews, things like that. So that was kind of my introduction to real estate. And then a few years later, so at the end of 2012, I joined as an employee, as an associate, a firm called Baker Soltz and Blum. And started doing a lot of foreclosures on those houses that investors had bought in 2007 and 2008 because they thought they were going to make a lot of money on them. And then most of them didn't. So we did a lot of foreclosure work at that point. Some foreclosure defense too. I've done some of that too. I don't do a lot of that now anymore. So did some foreclosure work, some landlord tenant work representing landlords. I've seen a lot of issues come up with like contracts for deeds. I never recommend those, so I've got a lot of like cautionary tales I could tell about, what I've learned along the way.
Right.
So.
Absolutely. So we wanted to talk a little bit about recording, and I don't know what kind of talking points you brought, but if you just want to kind of share some highlights and some tips with us, that would be awesome.
Yeah. So actually, where I would like to start is actually before recording, when you
Okay.
get to drafting those deeds. So,
Okay.
um, in case people don't know what a quiet title action is, a quiet title action is a lawsuit that has to be filed when, let's say, I sell you a property, Angel, and you buy the property, say for cash, no title report involved, you don't get a title report or something, and then you go to sell the property and you realize that I was actually married when I sold that property to you, and I did not have my spouse sign it. And so the title company says, "Well, Angela, you have to go back and find Audrey and make her have her spouse sign that, or make her sign an affidavit that she wasn't married at the time." And I might be dead. I might be living in Florida and you can't find me. I might say, "Screw you, Angel. I'm not doing that. You got to pay me another $10,000 if you want me to sign anything else. So then
Right.
you're kind of standing there going, okay, I've got this house I can't sell because the deed didn't have Audrey's spouse on it. So your recourse at that point, probably only recourse, depending on what a title company tells you, probably that's going to be your only recourse, is to file a quiet title action. And that's a lawsuit with the court that says, hey, I bought this property and there was this problem with the deed, and I can't find this person. I can't get them to sign it. I don't, whatever. So
Mhm.
if you can find me, you serve me. And if not, you serve me via publication. So you have to publish a notice in a newspaper. So this is a full lawsuit.
Mhm.
And that can be expensive and time consuming. It can take anywhere from at least 4 months up to, a year, depending on what complications arise, to get clear title to this property, and gosh, several $1,000s in attorney's fees.
Mhm.
So we want to prevent that. And if you prevent that, the way you start is by not preparing your documents yourself. And when I say who needs to prepare your deed then? Well, number one, I would recommend a title company. Especially with title company, if you had gotten a title company involved when you bought that property from me, the title company would say, "Oh, wait a minute, we need to know whether Audrey's married,"
Right.
and that would solve it right there. Now, when we come into, using a title company is optional when you're doing a cash sale, and that's where we get into problems. When there's a cash sale, we don't have to use a title company, and it's maybe a lower priced property, and you don't want to use a title company because that's going to cost money. You want to prepare your own deed. That's a problem. Um, Most attorneys will also prepare deeds.
Mhm.
Um, a lot of attorneys, though, are going to say, okay, I recommend you get a title report. I recommend you get a title commitment, title insurance, or at least an ownership and encumbrance report that will say for sure whether I have any old liens on that property, stuff like that. Because that's another issue that can come up if you're doing a cash sale, um, and not using a title company,
Right.
is that there may be an old lien on there. So.
Right. Yeah, that makes a lot of sense, but I don't, people really don't understand that. I'm on the opposite end. Like, I would have never known that I could do it without a title company. It was like, you just have to go through the title company. That's that's the
That's
way
the
to do
best
it.
thing to do. That's the best thing to do. Yeah, yeah, yeah. And I've actually had, I do some for sale by owner
Mhm.
documents as well, some transactions, and I always recommend. I've closed a couple of times, but I'm not a closer. I am not an
Yeah,
expert on that, so I really want. And now I won't do closings at all. I have the
yeah,
title company do that because they are the experts at closing.
right.
So.
And it's time consuming. So,
It is. It can, yeah, it is. It is. And there's lots of different pieces and, pieces to that that need to be
right.
taken care of. And a title company is really the best one, best entity to do that. One time I had a potential client contact me and say, well, I want to do a for sale by owner. What would you charge me? And I told them what my flat fee for a for sale by owner transaction would be for that property.
Mhm.
And he said, oh, that's kind of steep. And I said, well, actually, a realtor would charge you 6%, and this is more like 2%, So if you want to do it yourself, then go right ahead.
Yeah.
So
Yeah.
it doesn't have to be, more expensive to use a title company. You've also got to keep in mind you're putting a lot of money into the property, buying or selling a property, and it's especially if you're buying something, you want to make sure that your investment's protected. And having a
Absolutely.
title policy is important.
Yeah, and it's really not that expensive, to get an owner's policy, on it.
Right, and it's based on the fee is based on the sales price of the
Mhm.
property. So if you're only paying $10,000 for a property, maybe a distressed property,
Yeah,
it's gonna be less. So you're not paying the same for a $300,000 property as you would for a ten or $20,000 property.
yeah, right. So, well, and some people just they see that $300 and are like, "Well, I don't wanna pay that." And it's just paperwork. So, they just wanna do it themselves, and that's some of the things that, I've seen that we've had to untangle,
Mhm.
is, a family and inherited property and, they just somebody passes away and other people move into the house and they just live there and
Yep.
nothing's ever done. Um,
Yes.
and sometimes there's some documents that are sitting somewhere in the house, but they can't find them. They don't know where they are and they didn't really even understand what they were. Um, so, I find myself trying to help people dig out of these things, kind of after the fact, because I'm usually in the process of purchasing the property and trying
Mhm.
to, get stuff to the title company. And since we don't have a realtor involved, normally I'm that one running interference trying to get all the things that the title company is going to need to clear that title.
Right, right. So something you mentioned too is when somebody passes away, I've had to do because I do probate work.
Uh-huh.
And something I've ended up doing a lot is that exact kind of situation. Somebody passes away, and the heirs want to sell the property, but there's no uh, you know there's no beneficiary deed, there's no transfer on death deed, so the property is still in grandma's name and grandma's
Right.
deceased, and but they want to sell grandma's house. And so a lot of times what we'll do is we'll wait till 6 months or 12 months after grandma's passed away, and we do what's called a decree of descent in Kansas, or a petition for determination of heirship in Missouri. And that's an abbreviated probate action. You probably dealt with this before, abbreviated probate action to get title to real estate.
Mhm.
And again, that costs some money and it takes some time. It takes at least 4 months because again, you have to publish notice in the newspaper. Anything regarding real estate, you got to publish a notice in the newspaper.
Mhm.
But that can at least get title to those heirs so that they can then sell the property. And
Right.
sometimes it's not soon enough. If there's a mortgage on that property that is due, then they want to hurry up and do it right now, right now, right now. Well, I
Right.
can't.
Right.
It's going to take at least 4 months to do that, and somebody's got to pay the mortgage in the meantime if you want to keep the house.
Yeah. And so the beneficiary deed, and I've kind of talked about
Mhm.
that in the past in one of these, because that is one thing that, people, I hear real estate agents all the time saying, oh my gosh, if they would have just had a beneficiary deed, that would have made things so much easier.
And there's pluses and minuses to those as well, though. And I'll talk a little bit about some of my.
Okay.
I could tell war stories all day, Angela. So a beneficiary deed, it's also called a transfer on death deed. It's called a transfer on death deed in Kansas and a beneficiary deed in Missouri. Why we don't call it the same thing in both states? I don't know. We have to make things more complicated. All right.
Yeah.
So that says I own a piece of property. And upon my death, or upon the death of my husband and me, I want the property to go to this person, these people.
Right.
Okay.
Mhm.
In doing estate planning, occasionally I run into somebody who wants to be very specific with that and say, I want it to go to my kids, but if this daughter passes before me, then I want it to go to her husband. But if that daughter passes before me, then I want it to go to one of her children. Go, that's too complicated. That is beyond the purpose of a beneficiary deed or a transfer on death deed. We can
Mhm.
say something like, when I'm gone, to my daughter or to my children, my 2 kids, my 3 kids, whatever, per stirpes. And per stirpes means that it goes to that if they predecease the grantor, the person signing
Mhm.
this beneficiary deed, then their share goes to their children or their descendants. Okay. That's about the most complicated we could do.
Mhm.
Sometimes that's a good thing to have a beneficiary deed or a transfer on death deed, and other times it's not. Let me tell you about another kind of lawsuit similar to a quiet title, and it's called a partition action. Have you dealt with those? Okay.
No, I've
A
not.
partition action. So let's say mom passes. Mom has a beneficiary deed that says house goes to son and daughter. Mom passes away. We think, oh, good, everything's right? Everything's perfect. Son and daughter own the house. They can agree on what to do, except what happens if they don't agree? What happens if daughter lives in the house and says to her brother, screw you, you can't live here. I don't want you here. I'm going to live here. I'm not going to refinance it. I'm not going to pay you off. I'm just going to live here.
Mhm.
So brother has to file a partition action, and a partition action is an action asking the courts, a lawsuit
Mhm.
asking the court to sell the property or to order the sale of the property, and then to split the profits, split the proceeds between the parties. And then one of the parties can say, oh, well, all right, sometimes that's the incentive. One of the parties needs to get their mortgage application in, to get that refinance, to get that sale to go through. Sometimes they're not able to, and sometimes the court will order the sale to a third party, order it to be put on the market. Needs an appraisal, you need attorneys, you need publication, you need all that kind of stuff. So that's expensive. And that is a full blown lawsuit. I've had trials that are pretty contentious between family members. So if you're going to do that beneficiary deed or that transfer on death deed, number one, have somebody do it, have an attorney do it.
Mhm.
Title companies will not do those for you
Okay.
because that's the practice of law.
Mhm.
Um, have an attorney do your beneficiary deed. And number two, make sure that's really what you want. So in this case, if there had been no beneficiary deed, mom's estate would have gone to probate, and the probate court would have been dealing with that. Would it have been less litigation? Maybe, maybe not. It might not have been. It might have been just different litigation in the probate court instead of in a different courtroom. But
Yeah.
you know, again, we can do all the legal documents we want. We can prepare and prepare and prepare, but people are going to be people, and families don't always get along.
Right. Yeah. And that is definitely, I have ran into that many times.
Mhm.
And sometimes, I mean, I lose opportunities out of it really because people can't agree. And because they don't want to talk to each other, then they quit talking to me. And sometimes those houses end up, going to foreclosure or,
Or a tax sale.
yep, something happens because, they can't figure it out. And, I can't get them to talk to me. And, I've ran interference, a lot of interference between people where I'm like, okay, don't talk to each other. Just talk to me.
Yep.
But yeah, the family dynamics are definitely an issue. I always say that, we really need to be social workers in this because that's a lot of some of what I do is social worky
Sure,
stuff.
sure.
But I come from that, so I'm okay with it. But like, not everybody is like, why do I have to do this? This is like not part of being a real estate agent or, but a long-term real estate agent the other day told me, yeah, we all do this. We're all social workers. That's what we
Yes.
do. Uh,
Yes, yes, absolutely. Especially, with the housing market like it is right now. Yeah, I'm sure you do. And one of my law partners reminded me the other day that, we're called attorney and counselor at law, and we do some of that counseling, because I was
Right.
joking. I now offer therapy to landlords as well, as eviction actions.
Yeah. Well, and you might because, yeah, I mean, landlords, that might be harder to work with than families sometimes. Um, so yeah. Um, well, so tell us, you talked about quiet title. We covered that. So the other thing that I often see um, are quit claim deeds. Um, and when I'm doing, searching, often I'm searching for people because I found like a vacant house and I'm looking for the person who owns it. And I get and start to look at, the public records and I see, here's a quit claim deed and here's a contract for deed or here's, and the dates never match up. And so I'm always trying to untangle those. So when does a person use a quitclaim deed and how is that done appropriately?
So the most common situation is, okay, so let's back up. There's a quit claim deed and there's a warranty deed. And a warranty deed is the kind of deed that warrants good title.
Right.
And usually you can only give a warranty deed when you've got um, a title policy or a title, an ownership and encumbrance report that shows that you
Mhm.
do in fact have good title and you can give that title. After that, you can't really give a warranty deed. Um, Frequently what happens is, say I've got this house
Mhm.
and I don't know what kind of title I have to it. I may not have totally clear title. I may not be the only one on the title
Right.
that has an ownership interest in the house.
Uh-huh.
So I can only give the title that I have, and that's a quitclaim deed. That I'm giving away all the title that I have. I'm not warranting to you that that's the only title interest, that I'm the only person who has interest to that property, but I'm
Mhm.
giving you everything I have because that's all I can give you.
Okay.
Um, Problems we run into are, a lot of times quitclaim deeds don't recite whether somebody is married. That's important because in Missouri and in Kansas, a spouse has to sign a deed. Even if I am the only one on the deed, something I bought prior to marriage, my spouse would still have to sign off on that because my spouse has an inchoate interest in that property. And that means he doesn't have an interest now, but he may have an interest upon my death because of the probate statutes in the state. So that's one issue I see with quitclaim deeds.
Mhm.
One frequent use of quitclaim deeds are in divorce situations.
Mhm.
So you spouses own a house, and the divorce decree says that husband gets the house. So wife signs a quitclaim deed to husband saying,
Right.
"Look, everything, anything I own to this house, any interest I have in this house goes to you now." So that's an appropriate use of a quitclaim deed. I don't like to see quitclaim deeds used to actually sell houses. Like, let's just take the opposite situation. Let's say I own a house pre-marriage and I get married and I want my spouse to be on that deed as well. Then
Mhm.
I can quit claim the house back to myself and my spouse. That way my spouse is a legal owner of the house as well.
Okay. That's good, a good
Mhm.
explanation because I
Yeah.
see that. I see that and I'm like, well, this is weird. And so, yeah, where they're like, it's quit claimed back and forth to different people.
Yeah.
And usually
Here's
it's
a
a sale.
cautionary, yeah, here's a cautionary tale too about preparing your own deeds, or yeah, preparing your own deeds. Like, occasionally I've seen a title company do this. There is specific language that's needed to, so if two people are on a deed, either there's language that is required to say what happens if one of those people dies.
Mhm.
If it's tenants in common or if it's silent in Missouri, or in Kansas, if in Missouri, if it's silent. Okay, let me back up. In Missouri, if a deed is silent as to how these people own it, if they
Mhm.
are husband and wife and it says husband and wife, then it's the survivor owns the whole property. If it says tenants in common, or if the parties are not husband and wife, if it's parent and child, or siblings or something like that, or business partners or something, then each of those people owns half the property, basically. And when they pass away, their half will go to their heirs, either under their will or their trust or intestate succession or whatever. In Kansas, we have to have the specific language as joint tenants with the right of survivorship. Just using the phrase husband and wife does not cause that to happen. And I have seen a couple of times a Missouri title company do a Kansas deed and not put in joint tenants with the right of survivorship, just put husband and wife.
Yeah.
And that is an error. And that is a claim on your title insurance.
Yikes.
Yeah.
Yeah, it is so complex, and knowing how to do it the right way. I always recommend that people use professionals, including not me. I'm like, I can tell you generally what this is like and what to do, but I recommend that talk to the title company or an attorney if you have one, specifically a real estate attorney. So I also don't advise people to go, use some other kind of attorney generally, because sometimes people want to do that. They're like, well, I can use my tax attorney. And I'm like, well, I kind of think maybe you should talk to somebody that has some experience doing this. So even if people are qualified, doesn't necessarily mean they should be doing certain things. So but
there again, when a title company messes up, that's what there's title insurance for that.
Absolutely. And you're protected. Hopefully, that's what's protecting you in the future. So
yeah, and if I screw up, I've got professional malpractice insurance. Let's knock on wood that doesn't happen.
Right.
If you screw up selling your own home or trying to do it yourself, then you're just kind of out of luck.
Yeah. Well, and even in for sale by owner situations, I don't necessarily, expect people to always use real estate agents, but, using a title company, seems to be a necessity to me, that you have all of that paperwork, done
Yes.
in the appropriate way.
Especially always insist on that if you're the buyer.
Yeah.
You need an owner's policy. Yeah.
Yeah. So, well, we're at 27 minutes now. I don't want to take up too much of your time because I know you're busy with really important things. Are there any last minute kind of tips that you want to share? And then how do people get in contact with you if they need some of your services?
Last minute tips. I guess know when to not do it yourself. That's kind of the theme, I guess, of our conversation here.
Yeah.
And know what kind of professional to use. I've also seen a couple of real estate agents realtors that will, prepare deeds or leases or something like
Really?
that, which again is number one, it's the unauthorized practice of law. And number two, puts people, homeowners and tenants in really bad situations sometimes.
Yeah.
So always make sure you're using the correct professional.
Right.
A title company, having a good title company you can talk to that can say, yes, this is something we can do, or no, this is not something we can do. You need a real estate attorney for that. That's really important to have.
Yeah.
My contact information, I am at Audrey at kcpropertylaw.com. K is in Kansas, C is in city. And my number is 913-391-7055. And if I can't help with something, I probably have a referral for you.
Okay. Give me your phone number one more time.
Yeah, 913-391-7055.
I'm dumping it in the chat here. So it will live out here if you get phone calls. Hopefully that will be okay. So Is definitely we want to drum up some referrals when needed, and help people get connected to the resources that they need. And I think a real estate attorney is often needed, and also a state. I love that you also offer that piece, because for some people there's a lot of overlap.
There is usually a lot of overlap. Yeah.
Yeah,
Yeah.
and I mean, just from personal, it's like for me, I sometimes, and this I'm disclosing my own issues. I will avoid things because I don't know really who's the right person to go to, you know? And so it's like, well, do I start with this person? Do I start with this person? Can they cover all of these things? And so it rather than, trying to sort all that out of who does what, I just avoid it. I'm like, well, I don't know, because everybody's like, oh, well, I can do that for you, but are they the right person? And so I can't make a decision. And um, but yeah, the whole, I mean, it's complex, and you do want to have
Yes.
the right person doing it for you. But for me, I'm like, I don't want to work with a whole bunch of different people. So it's better if I can get, kind of a one-stop shop for a lot of the things, within um, a well, what do I want to say? Within the competency area, I don't want somebody that's doing like my tax attorney doing, my real estate stuff.
Right.
That's not something that I would be like, oh, I want to have one attorney do everything for me. But as much as possible, it makes sense. As I'm a big picture, I believe in the big picture, and the more you know about me, the better you're going to be able to serve me. So, um, but I appreciate your time today, and if there's
Of
anything that
course.
we can ever do for you, from our company perspective, we'll definitely send you referrals when we can. And I will probably be connecting with you as well on some personal or individual things. So,
Okay. Yeah.
uh,
Well, I look forward to visiting with you more, but this was very nice today. Thank you for having me, Angel.
all righty. Thank you. Talk soon.
Bye bye.
Bye.